So consent orders are a legally binding document that gets lodged with the court, and if the court approves them, they become final orders, which will thereafter sort out your property and financial matters. In terms of consent orders, the first and most important thing is that yourself and your former partner reach an agreement. Once you have an agreement, the application for consent orders is then drafted to formalise your agreement. That then gets lodged with the court, and once it's approved by the court and made into final orders, it is as if a judge has made those orders at a final hearing. One of the main benefits of getting consent orders is the stamp duty exemption. When you transfer property from one party to another party, if you don't have consent orders, stamp duty is payable, and that can be upwards of $5,000, $10,000, $15,000, $20,000 depending on the property in question. Another main benefit as well is the fact that your agreement becomes legally binding. Yourself and your former partner, although you may be amicable now, you never know what's going to happen in the future. So getting it legally binding, made into court orders, will help you have that certainty moving forward with your life. So once the consent orders are made into final orders, usually there's obligations on parties to do certain things such as transfer a property, refinance a mortgage, they might have to take on a joint car loan, etc. And if those obligations are breached, you can go back to court and have those orders enforced, or in an extreme circumstance, have those orders set aside for new orders to be made. So enforcing orders is the process of asking the court to compel the other party to do something they haven't done under the orders. So, for instance, if they haven't signed a transfer document, which is required for you to transfer the property to your sole name, you can ask the court to say, this was an obligation on my former partner to do, they haven't done it, can you please make some further orders so that I can actually get the property transferred into my name? If the consent orders are breached, you can take your former partner to court to get those orders enforced so that your former partner carries out their obligations as required, and you can ask the court to make a costs order against your former partner to pay the costs that you have incurred to enforce the orders. So the most common situation that we see in terms of parties using consent orders for is to transfer a joint property from one person's name into the other person's sole name. This situation involves firstly having the property transferred from joint names into the sole person's name, a mortgage being refinanced from joint names into one person's sole name, which will release the other person from the mortgage, and sometimes as well a cash payout from one party who's keeping the property to the other party who's not keeping the property. The cash payout can be calculated based on the equity in the house, which is the value of the property minus the current mortgage owing. A superannuation split is where one party's superannuation in their fund is split to their spouse's superannuation fund directly. So an example of a superannuation split is when John has been working for the entire relationship and has accrued $200,000 in his superannuation. His partner Jane hasn't worked as much during the relationship and only has about $80,000 in her superannuation. So to make their agreement more fair, John has agreed to pay Jane $40,000 from his superannuation fund. Once you've agreed on a superannuation split, the process to effect that superannuation split is complicated. Once all the steps are followed correctly, John's super fund will be able to transfer the $40,000 directly to Jane's superannuation fund. In relation to superannuation, you don't need to split superannuation in all circumstances. Again, it depends on your situation. Overall, some people do and some people don't. Your agreement doesn't need to be exactly 50-50. Relationships are of various lengths. There's multiple factors involved, such as who's worked, who hasn't worked, both parties may have worked. There's children that's involved, one party may be older than the other party, one party may have some health issues. So a 50-50 agreement isn't always guaranteed to be accepted by the court. Your agreement doesn't need to be 50-50. So our process is, once we're engaged, we send you out some information for you to gather and get back to us. Once we receive that information, we have a conversation with you over the phone so that we can fully understand your agreement and ask you any final questions that we need to draft your application for consent orders. We then draft your application for consent orders, and once that's done, we then provide you with a copy for your review. Once you're happy with the documents, we send you some signing instructions so you get those signed. Once the documents are signed and they're returned to us, we will review the documents to make sure they're signed accurately, and if they are, we'll lodge them with the court for you. Once your documents are with the court, you'll be set a consent orders hearing, which usually is about 4 weeks after the time of lodgement. You don't need to attend the hearing. The court simply reviews the application that you've made to the court, and if they believe your agreement is fair, they'll make your consent orders into final court orders. So when you make an application for consent orders, the court needs to make sure that the agreement is fair on both parties. This can provide assurances for both yourself as well as your former partner potentially that the agreement that you've entered, if it is made into final orders, is fair for both parties. Generally, if the court deems your agreement to be unfair, they'll give some indication as to which party they believe the agreement is unfair on, and generally they'll ask you to give you some more information or for the parties to seek some legal advice. Once your consent orders are made into final orders, usually you'll have some timeframes in place for both yourself and your former partner to carry out the obligations that those orders impose, such as transferring the property, refinancing the property, if any transfers of any cars need to be done, closing joint bank accounts, that sort of thing. So in terms of timeframes and how long the process takes, once we have all the information that we need, we've had our conversation with you over the phone, it's usually 1 to 2 weeks for us to draft the documents. Once you approve those documents, it's then over to you to get those documents signed and back to us. And once the documents are signed, they've been signed accurately and we lodge them with the court, it's usually about 4 weeks to get your consent orders hearing and final orders made. However, depending on the time of the year, for instance, if you're closer to Christmas, the timeframes can extend longer than that. Doing consent orders is best done as soon as possible after your separation, provided that yourself and your partner are amicable and can reach an agreement. Leaving your consent orders to 2 or 3 years down the road after your separation could lead to complications, particularly if you start carrying on your life, acquiring new assets, you enter a new relationship, children come into the picture potentially. It's easier done sooner rather than later. Getting your consent orders done sooner rather than later allows you to move forward with your life and I guess reap the benefits potentially of any assets acquired post-separation, any increases in value potentially of any assets, as well as providing the certainty that you know your former partner won't be able to make any claims or have any interest in those assets or the increases in value that those assets have accrued post-consent orders. So we have seen plenty of examples where parties have left their consent orders to 3, 4, 5 years later down the track, and in respect of businesses potentially, the business has increased dramatically 2 or 3 times its current value. It's better to get your consent orders done as soon as possible so you can protect yourself moving forward, because the court does have the ability to split or look at the assets that you acquire post-separation as well as any increases in value. We've seen countless situations where parties have left their consent orders to 2 or 3 years after separation. The value of an asset, potentially a house, a business, has increased 2 or 3 times what it was at the time of separation, and the other party has been able to gain access to that increase in value. If they did consent orders before any increase in value of a property or business, their former partner wouldn't have had any entitlement to that increase in value because the consent orders finalise your property and financial matters at the time the orders are made.